I'm lead judge Ifti Ahmed from the Patent Trial and Appeals Board, and I'll be your moderator today. And I'm thrilled to be here with Acting Deputy Chief Judge Cal Deshpande and Acting Director Review Executive and Senior Legal Advisor, Judge Michelle Ankenbrand. And today we will be discussing the interim processes relating to institution of AIA proceedings. But before we get started with the presentation, I'd like to go through some housekeeping issues. First, if you have any questions about the interim processes, please send them to us now. Please do not put them in the chat box. Instead, please email them to the email address that you see on your screen now. It's usptohour@uspto.gov. You can also find this email address in the chat box during the presentation. And a couple of tips on questions. Please email your questions as soon as you can. It takes us some time to process your questions and present them to the judges. And second, make your question direct and focused, 1 or 2 sentences at most. Questions that are longer than that are difficult to address in this format. If your questions are concise, we can respond directly to your issue. We welcome your questions, and we hope to get to as many of them as possible today. Also, I'd like to remind everyone that copies of the slides from this presentation will be posted to the USPTO Hour website soon. In addition, we'll post a video recording of today's presentation in a few days. So without further ado, let me hand it over to Judge Deshpande to discuss the interim processes.
Great, thank you, Ifti. Can everybody hear me?
Yes.
I'll take that as yes. Okay. Why don't we go ahead and move on to the next slide. We have a pretty expansive agenda for today. There's a lot to cover, but before we get into our agenda, I just want to make a quick disclaimer. Today's USPTO Hour is a presentation and discussion on updates on the interim processes. We're doing our best to provide updates in real time. Parties appearing before the office should not cite to any particular statements made during this presentation as controlling authority. We will discuss a little bit of a new webpage that will provide all the information that we're covering, and parties can cite to that webpage or the interim memo as appropriate, but they should avoid citing to any statements made during this presentation. Now that I've gotten that out of the way, let's talk about today's agenda. We're going to go over a little bit of history as to how we got here, going over the interim processes memo, some of the issued frequently asked questions. We'll go over some statistics as to what we have been seeing so far and talk about some exemplary fact patterns that have come up. There are some updates, so please make sure you stay tuned for those updates to the processes. And then we'll have a quick set of takeaways, and then we're happy to answer any questions that folks might have. Sound good? Why don't we go ahead and move on to the next slide. As a quick reminder, on March 26, 2025, the acting director issued a new memorandum on interim PTAB processes. You can find this memo on the website, on the PTAB pages. You can find, I think Brandy just put in a link. You can find it there. The purpose of the memo is to increase efficiency, maintain capacity in conducting AIA trials, reduce pendency as ex parte appeals, and importantly, to promote consistency and discretionary considerations. Next slide. The interim processes bifurcated the decision on institution phase of a trial. The interim processes broke the decision on institution phase into 2 parts: discretionary considerations and merits and other non-discretionary considerations. Next slide. The director is going to handle the first part of the bifurcated process in determining whether discretionary denial is appropriate of a proceeding, and if not, the board will handle the second part of the bifurcated process, where the board will address the merits and other non-discretionary issues. In order to help the director decide discretionary considerations, the parties may file briefs. Earlier on, we had some frequently asked questions that talked about some extension to due dates as we were getting the process up and running. All of those time periods should be over now, so a lot of those frequently asked questions no longer apply. In general, patent owner's brief is due 2 months after the notice of filing date accorded, and petitioner's brief is due 1 month after the patent owner's brief due date. Next slide. The process memorandum includes a non-exhaustive list of considerations. This includes PTAB's precedential decisions in FinTIV, in general plastic, and advanced bionic, guidance from the trial practice guide. The memo also lists out some more considerations. I'm not going to read through all of them. You can take your time in reading through all of them. I will highlight the last one. Any consideration that might bear on the director's discretion, we'll talk about that a little bit more in detail as we get through it. But I just wanted to highlight that last consideration that parties should really develop and present any consideration they think bears on the director's discretion. The director's decision will be based on a holistic review of the facts and circumstances. As you might guess, there are two possible outcomes from a director's decision. The director may decide that discretionary denial is appropriate. If that's true, then the discretionary decision denies the petition and no trial is instituted. The director may also decide that discretionary denial is not appropriate. In that situation, the director refers the petition to the board to assess the merits and other non-discretionary considerations. That's a review of the interim processes memo. I'm going to turn it over to Judge Enkenbrand to discuss our frequently asked questions that we had posted.
Before I hand it to Judge Enkenbrand, just a reminder for those of us who just joined us, if you have questions about the interim processes, please send those to the email address on your screen now, usptohour@uspto.gov. Please do not put them in the chat box. With that, let me hand it to Judge Enkenbrand.
Thanks, Judge Ahmed. If you can advance one more slide, please. So those of you who may have joined our April board side chat heard Judge Deshpande and me talk a little bit about how the office was creating FAQs to help answer some of the questions that stakeholders had around the interim processes. As you all probably know, we published those FAQs in April of this year. And at the time, you may have noticed that some of the FAQs were a little bit different from the information that we presented during the board side chat. This was intentional because we used board side chat questions and dialogue that we had with you at the time to help revise some of the questions and answers that we originally put together. So the FAQs that were published on the website provide information about things like availability and timing, the procedures and processes, briefing requirements, requests for director review or rehearing, new paper types for filing briefs, and conflicts of interest. The FAQ page also indicated that the office may update the FAQs after some experience with the interim processes and reminded people to check back frequently for updates. Next slide, please. We actually made 2 updates to the FAQs based on our experience with the process. Specifically in May for FAQ 8, we added some information about the director consulting with USPTO personnel with relevant technical expertise when arguments were presented that related to the strength of the merits. We've also used the consultation for 325D arguments because those generally touch on the merits. And then in July, we added a new FAQ 10, which you can see on the screen here. Essentially, it says that the acting director ordinarily will rely on facts and circumstances the parties raise in their briefs and will consider additional circumstances where appropriate. And some examples are to maintain consistency with already issued discretionary decisions, where there are facts and circumstances within the purview of the office or office operations that the parties are not in a position to raise, or where there are facts and circumstances in the record or the public domain that are relevant to the determination. With respect to facts and circumstances within the purview of the office, one example of that is the fact that the office has limited resources and the office and not the parties are aware of those limited resources, and that is something that the director can consider when determining whether we can efficiently administer or timely complete proceedings. Next slide, please. And you can forward one more. So although the interim processes have only been in effect for a short time, just a few months, we do have some preliminary statistics to share, and these statistics are current through August 11th. You'll see on the charts in the slide that there's a reference to DSCO. That just stands for discretionary considerations. So if you look at the chart in the upper left, you'll see that of the 632 cases that were eligible for discretionary considerations decisions, most of them most of the patent owners have request discretionary denial. So that's about 82% is what we're seeing. Also, if you look at the chart to the right, upper right, the discretionary considerations decisions issued, there have been close to 300 discretionary consideration decisions mailed since the processes began. One thing that's notable is that all of the discretionary considerations decisions have issued within 1 month of the last relevant paper being filed. And you can see from this chart that it's about a 60-40% split between denials and referrals. But one thing that I wanted to call out about this is that related cases can skew the numbers up or down. So again, it bears repeating that we're still early in the process, and these numbers may look different once we have more months under our belt. If you look at the bottom chart, you can see that all of the decisions for June and July were mailed, and we're now working through the August decisions with over half of those mailed. Next slide, please. So we wanted to highlight a few exemplary fact patterns that have either supported referral or denial, since I know oftentimes parties are kind of looking for that guidance in determining what to file in their own briefs. And I would say just a little disclaimer up front, although we're highlighting some fact patterns and decisions, I would encourage everyone to read as many decisions as they can, as the acting director Stewart is weighing multiple considerations in many of the cases. And I think it's also helpful to read the briefs that have that the parties have filed. So if you really want to make an argument supporting referral, one thing you can do is look at cases where the director has ordered referral to the board and look at the briefs that the parties have filed in those cases. I'm going to start with referrals, and then I will hand it back to Judge Deshpande to talk about exemplary fact patterns that support denials. One of the most common fact patterns that we've seen that has supported referral is when a petitioner identifies an apparent material error during examination. And so what does that mean? I'm not just talking about a petitioner raising prior art that the examiner didn't find. The cases that we've seen referrals in are cases where the examiner has made a finding or an omission that appears to be erroneous. One of the cases that we've highlighted here is the Patages case, and that's an example. In that case, again, I invite you to read the briefing, but petitioner made a well-supported argument that the patent examiner may have made an error in determining that the challenged claims were entitled to the priority date of the patent's provisional application. You'll also see in the briefing and in the decision that there was a prior board proceeding involving a related patent with overlapping claimed subject matter, and the board determined that the related claims were not entitled to the priority date of that same provisional application. So that's kind of one example we've been seeing. And we do have a feedback loop for these cases. So when Acting Director Stewart issues a decision referring a case to the board because it appears that the examiner made an error material to patentability, the acting director is providing those decisions, oftentimes walking them down the hall to the patents team. And so there is this feedback loop coming from the interim processes to the patents team, and they're looking at those decisions and seeing what they can do in the course of patent examination. Turning to the next exemplary fact pattern, Acting Director Stewart has often referred PGR challenges. And as you recall, those can only be filed within the first 9 months of issuance. And they are close in time to the patent's issuance and occur before a patent owner's expectations rights are strongly settled. So one of those cases that we highlighted here was the Multicolor Corp case that's noted on the slide. In that case, the challenge patent was asserted in 2 district court proceedings, with one trial scheduled for 4 months before the final written decision due date. Nevertheless, the acting director found that referral was appropriate because it was an early challenge to the patentability of the claims. The last fact pattern and case we wanted to highlight was the Stratasys line of cases. So it's one decision that relates to a number of cases. One of them is highlighted on this slide. In those cases, the petitioner provided evidence that the challenged patent had never been commercialized, asserted, marked, licensed, or otherwise applied in petitioner's technology space. So arguments like the ones made in Stratasys that are fully developed and supported with evidence can be very effective against settled expectations. So what is sort of the main takeaway from these exemplary fact patterns? I think what I would emphasize is that parties should keep raising arguments on all facts and circumstances, and make sure that they're fully developed and supported with evidence. So don't just say, my case is like the Stratasys case because patent owner hasn't commercialized, asserted, marked, licensed, or otherwise applied the patent in my technology space, period, end of analysis. Tell us why that's happened. Cite some evidence that shows that. And so for me, that's the main takeaway here. I'm going to turn it back over to Judge Deshpande now.
I think that was great. Thanks, Judge Eckenbrand. That's a great segue into sort of the first fact pattern we're going to talk about when it comes to cases where the discretionary consideration supported denial is unfair dealings. Often there are facts and circumstances that exemplify that something has been unfair in the dealings between the parties in the past. In the Tessel case, this is a situation where the inventors applied for a patent, were issued a patent, and then later challenged the patentability of the patent they received. In those situations, the discretionary considerations weighed in favor of discretionary denial. I think this sort of building on what Judge Eckenbrand said, that providing the information and any reason that you can that bears on the director's consideration is important, and to fully develop those arguments so that that she can understand exactly what your position is. Another exemplary fact pattern that supported denial is settled expectations. In the Dabaco case, there was a patent that had been enforced for about 8 years. Now, there's no bright line rule as to when a patent owner's expectations of a patent become settled. The longer a patent is enforced, the more settled expectations can be. In this case, the patent had been enforced for about 8 years, and the petitioner had not provided any reasoning as to why the challenge patent should be reviewed. So again, it goes back to setting forth your positions and your reasonings as to why the considerations favor your position the best. The last fact pattern that we'll talk about here is the Intel Proxense case. It's similar and it builds on the Dabaco decision, but it puts out some more information as to what petitioners may argue as a reason why the office may disturb a patent owner's settled expectations. One might be a significant change in the law from when the patent issued until now, and the other might be that the patent has been enforced for years, but it was never commercialized, asserted, marketed, licensed, or otherwise applied in a petitioner's technology space. So I think even the fact patterns that support denial, the more those fact patterns are developed and clearly explained and thoroughly set forth, the better the positioning can be in terms of supporting the position you're trying to go for. Again, these are, like Judge Ankenbrand mentioned, these are exemplary. These are really brought together for our discussion. The director definitely considers every consideration that's raised in the case, and based on a holistic assessment of all the considerations, renders a decision. Next slide, please.
I'll jump in to remind everyone that we will be answering questions at the end of this presentation. Please send in any questions that you may have to the email address on your screen, usptohour@uspto.gov. With that, I'll hand it back to Judge Deshpande to talk about some updates to the interim processes.
Great. Thanks, Ifti. Let's go to today, we're going to retire the frequently asked questions, the ones that Judge Ankenbrand talked about in the beginning that were issued in April based on our last USPTO hour. Those are going to be incorporated into a web page. The web page, I think Brandy just put it in the chat box. So it is live and available right now. You can go ahead and take a look at it right now. The web page is generally organized to make it easier to find some information. All the information from the FAQs has been incorporated into the new web page. There are organizations so that petitioners can find what they need to know, patent owners can find what they need to know. There's information about the director's discretionary decisions, how to find them, how to file them. Everything is organized in an outline format. It'll look very similar to the board's director review webpage, where it should be easier to follow, and all the information is current in there, and it has incorporated all of the information from the FAQs into the new web page too. Next slide. Based on some learned experiences, we are making a change to the page limits. Under the interim processes memorandum, parties were able to file 14,000 words for patent owner and petitioner's discretionary briefs. What we have noticed is that the briefs have been substantially shorter than 14,000 words, especially the briefs that are very clear and succinct in developing their arguments. They can make their arguments quite briefly, and they can be the most impactful ones. Based on this experience, we're going to go ahead and reduce the page limits to 20 pages. So instead of 14,000 words, the new limit is 20 pages. That's going to be effective for all briefs that are going to be filed after September 1st. So all patent owner discretionary briefs and all petitioner discretionary briefs filed after September 1st will be limited to 20 pages. Just a reminder, I think many folks already know this, that you should follow the formatting requirements of 42.6 that tells you what the page size, the ink color, the font size, the font type, all of just the basic information. Make sure you continue to follow those. I know for some people, 20 pages is not enough. In the situation where 20 pages is not enough, the parties may request additional briefing by demonstrating good cause. You can send those requests in to director discretionary decision at uspto.gov. As always, it's great if you confer with opposing counsel before you request additional pages. But please, if you need more than the 20 pages, the availability is there. Just demonstrate the good cause and send the email. But for most cases, 20 pages should be sufficient. Next slide. I'm going to walk us through a little bit on how to find a director discretionary decisions. It allows you to find them through the USPTO, the PTAB decision portal. All you have to do is go to the PTAB webpage, select all PTAB decision data. That's in the middle column of there's 3 columns on that page. In the middle column, it's the first thing you can select. Once you go to that page, in the upper left-hand corner is a couple different tabs. There is a documents tab. That documents tab is listed just underneath the words PTAB decisions. From there, there's a bunch of filters on the left-hand side of the page. you want to search under the document type filter for director discretionary decision. It'll pull up two options. It'll pull up director discretionary decision : refer, and director discretionary decision : deny. Once you select both of those and click on apply, it'll give you all of them. There's been quite a few that have already issued, so it'll fill up your page right away. I think there's been about 294 cases where they've been mailed in. So the page fills up quite big, but it'll give you every single decision that the director has issued on discretion. Next slide. One more slide. All right, just some takeaways from what we have learned over the course of the last few months in the discretionary process. We've seen an increase in efficiency. We're operating with a team of 10 to 12 that are working on all the discretionary decisions and assisting the director in making deciding discretionary decisions. That's in comparison to what was before. It was over 100 judges that were applying all of the discretionary considerations. So there has been an increase in efficiency. I'll turn it over to Judge Ankenbrand.
Thanks, Judge Deshpande. Also in our statistics, we've seen discretionary briefs, again, filed in most eligible cases, about 82% of cases, and all decisions have issued within 1 month of the due date of the last relevant paper filed. Of course, we also have the updates that Judge Deshpande just referenced. So the new website that's rolling out today, which I encourage everyone to take a look at. We're retiring the FAQs. We will archive them on our website somewhere, and maybe we'll put the link to the archive in the website as well, so folks can find them, and the 20-page limit for briefs that are to be filed on or after September 1st.
I think Judge Ankenbrand shared some statistic before. All decisions from the director have issued timely. They've all issued 1 month of the due date of the last relevant paper filed. So all decisions have been mailed timely. That can be attributed to both the efficiency and consistency that we have experienced. I know everyone might be clamoring for some more information. Stay tuned. More information will be forthcoming. Stay tuned for some designated decisions if things are designated informative, and some future rulemaking on any of these topics. I think with that, Ifti, I'm going to turn it back over to you.
Thank you, Judge Deshpande. We have received quite a few questions, so let's get started with the questions. I'll ask you the first one, Judge Ankenbrand. You've given us a lot of information today about the interim processes, and there's also information in the original memo, the original FAQs, and the new webpage. Between these various sources, what information should parties rely on?
Thanks, Judge Ahmed. So as we noted, the FAQs are being retired today, and we'll have a dedicated webpage for the interim processes. As Judge Deshpande said earlier, most of the information from the FAQs is captured in the new webpage. And for controlling authority, members of the public, parties, stakeholders should consult the interim processes memorandum and the new webpage. I would also add a note to remember to check the webpage often, because we may update the webpage based on our experience with the process going forward. And typically when there's a webpage update, we don't send out an email alert to subscribers, but we do, when we publish the webpage, put a little update sticker at the top and let folks know when the webpage was updated and which section or sections was updated. Again, this USPTO hour, just like the board side chat, is informational and not intended to be controlling authority.
Thank you. Judge Deshpande, I think you touched on this a little bit, but can you tell us about how the discretionary process works from the USPTO side? What is the intake process?
Yeah, that's a good question. Once discretionary briefs are filed, it starts with the patent owner brief, and once it's filed, we're obviously cataloging them. We have a team that receives the case, indicates that we've received the case. From there, we immediately move to make sure we understand what conflicts the director might have or anyone on the team might have. So we manage to make sure that no one who is conflicted from reviewing or working on the case is a part of that case. From there, we have a team, like I mentioned, we have about 10 to 12 folks on the team that sort of work through a case. They will break it down. They might research relevant case law. They might go review facts that they need to include into a discussion. And the entire team sort of discusses the case and all of the metes and bounds of where the arguments are. And then the director, along with the 3 senior judges and our senior advisors, will actually sit down and have a full discussion on the case. So there is a whole process that goes into it. A lot of these cases, all these cases have been decided. The last paper comes in and a decision from the director is due a month later. So a lot of things happen in between that time that last paper is received and a director decision is actually drafted and entered.
Thank you. Judge Ankenbrand, can you talk a little bit about how the acting director is involved in this process?
Sure. I think Judge Despande talked about it a little bit in answering the last question, but one thing to note is that Acting Director Stewart is involved in every decision, of course, unless she has a conflict in the case. And as Judge Despande mentioned, once the case is ready, 3 senior PTAB judges will meet with the Acting Director and her senior advisors to discuss the case. During the meetings, there's a walk through the facts and circumstances of each case and the arguments that the parties raised in their briefs. Each discretionary consideration argument is reviewed individually and then balanced holistically. So often there's a healthy, robust debate about which side of the scale the specific discretionary consideration falls on. And then we also are making sure that we review issued decisions to maintain consistency. All of this discussion is helpful for the acting director in making her decision whether to refer the case to the board or to deny institution. And I will say now that the process has been ongoing for several months and the discretionary considerations team is seeing similar fact patterns in cases, they're getting pretty good at predicting how the acting director will decide a particular case, but it's always her decision and she is the one making the decision and issuing the opinion, of course, unless there's a conflict.
Thanks.
So all that to say is that she's highly involved in the process.
Thank you. And along the same lines, what is the acting director looking for in the briefing? If you could shed some light on that, that would be good.
Sure. And I think we both spoke about this a little bit during the presentation, but she's looking for the parties to raise and fully develop their arguments. So the way I think parties should be approaching this is that the office has limited resources and the parties' briefs should assist the acting director in determining whether taking up the case is an efficient use of the office's resources. As one of my former colleagues used to say when she was out speaking about practice tips for PTAB, help us help you. So there's not much that we can do with an argument that's not fully developed and not supported with evidence. And it's not helpful to simply cite a decision that the director has issued in another case and stop the analysis there. So I think as I explained, in the Stratasys cases, we saw petitioners argue that the challenge patent hadn't been commercialized or marked in the petitioner's technology area. And I think a good argument could be making that, citing to the Stratasys line of cases, and then delving into the facts of your own case. So citing a case is good as a guide or a starting point, but I think a brief that really is an impactful brief is one that goes deeper into the facts and circumstances of the case before the director, not another case. Another example, some petitioners have argued that they have settled expectations due to a business relationship with a patent owner, but then the briefing doesn't fully develop why the relationship equates to settled expectations. For example, were there conversations and did the patent owner say that petitioner was not infringing the patent? Is there something else relevant to the determination? Also, parties oftentimes will argue settled expectations by simply relying on the time that the patent has been in force. There are some guideposts in the decisions about when a patent owner's expectations become settled, but other facts and circumstances may be even more persuasive. For example, a patent may have only been in force for a short time, but the patent owner may have invested millions of dollars to bring a product to market. If that argument is fully developed and supported with evidence, it can be relevant to a patent owner's settled expectations. So those are just some examples of what the director is looking for, the acting director is looking for in the parties briefing.
Thank you. I'll ask Judge Deshpande the next question. With the new 20-page limit, how do images count? Do you subtract images from that page limit?
No, the page limits were provided to really simplify the process. I know images take up space, but they do count towards the total page limit. In our experiences, the 20-page limit accounted for the images. But like I mentioned earlier, if you need more pages and you have images or a lot of images that take up a lot of pages, that might be a good reason or a good cause showing for requesting additional pages. You can certainly ask for additional pages.
Okay, thanks. I've got a few questions that are a bit too specific. Is there an email address that people can send such questions to?
Yeah. Maybe Brandy can put this in the chat box. It's director_discretionary_decision@uspto.gov. Just whenever you do send case-specific questions, remember to include opposing counsel on those emails. And it's always better if you can confer with opposing counsel before sending emails. That saves everybody a lot of time in terms of trying to figure out where everyone's positions are.
Judge Aikenbrand, I'll go back to you. If someone would like the director to reconsider her discretionary denial decision, what is the appropriate avenue for that? Do they file a rehearing request, a director review request, and what is the timeline for that?
Sure. So for a decision that refers the case to the board, any party who wishes to request rehearing or director review has to wait until the board issues its decision on institution to file that request. If the requesting party is seeking to raise discretionary issues only or discretionary issues and merits issues, then the party has to file a request for director review. But if the requesting party is only seeking to raise merits issues, that party can file a request for rehearing to the panel or a request for director review. And for a discretionary decision denying institution, a party can file either a request for consideration or a request for director review. We've had both been filed already in the process. And if that is the case, the party has to file the request within 30 days of the issuance of the decision that denies institution.
Okay, thank you. Judge Deshpande, you mentioned the new web page. Will the director's decisions be posted on that web page, similar to the director review decisions?
No, they won't. They're going to be posted sort of the way I explained before by going to the PTAB decision data webpage. There's just simply too many decisions, and the frequency of issuing them is too vast for us to maintain something separate from our regular data portal. that PTAX provides. So they will not be posted separately, but it is a pretty simple process to be able to find them through the PTAX data portal.
That makes sense. Judge Enkenbrand, if a request for an IPR on a first patent, for example, a parent patent, was denied discretionarily based on settled expectations, can parties expect subsequent IPRs for the rest of the patent family to also be denied if the prior art is the same?
I would say not necessarily, because each case stands on its own. There have been split decisions that the acting director has issued involving related patents. One example of that is in Amgen versus Bristol Myers Squibb. One of those IPRs is IPR 2025-00601, also 602 and 603. That decision determines that the patent owner had not developed strong settled expectations in one patent that was enforced for 3 years, but that the patent owner had established strong settled expectations in 2 other related patents. So I would say make your best fully developed arguments, and don't just assume that because one IPR was discretionarily denied on a parent patent, every other one will be discretionarily denied as well.
Okay, thank you. Judge Deshpande, a question about deadlines. Are the deadlines for patent owners' preliminary response and the petitioner's opposition to the request for discretionary denial, are those deadlines structured to fall on the same date, or are those independent of each other?
They're independent of each other. They were expected to be close in time, so that they can be responsive as needed. But they're independent of each other. They're not expected. They were not. If one moves back, that doesn't require the other one to move back, but for good reason.
Okay. And I'll ask you this question: given all the discussions that go into these decisions, there must be disagreements from time to time. And the question is, how are those disagreements resolved?
Yeah, there are. Everyone has a different perspective on cases. That is necessarily true. As far as the team discussion goes, and into the discussions with the director, you've noticed the decisions include one person's name on there. They're the acting director's decision. So in order to resolve the disagreements, the director decides the case in the end. They're her decisions.
Okay, thank you. Judge Enkenbrand, if the discretionary denial brief is due before September 1st under the current page limits, what does petitioner have to do for the opposition brief?
I would say, and I would defer to Judge Deshpande because he probably knows more about this, but I think if patent owners getting 14,000 words, still a petitioner can have 14,000 words, even though the page limits are moving on September 1st. So if that's the case, I would send an email to the director discretionary decision mailbox and just confirm that. So if you do fall within that period where patent owner is getting 14,000 words, but your due date is after September 1st, please reach out to the mailbox, and which I think has just been posted in the chat, and the team can respond to you then.
Let me just follow on to that. Yeah, we're intending to have the briefing be equal. So if opposing party has gotten 14,000 words, then petitioner certainly will get 14,000 words. If you're not sure or you want confirmation, please do email the mailbox Brandy just posted, and we can make sure that everyone has a correct understanding of what's expected.
Thank you. Judge Deshpande, there's a question from an independent inventor. If someone were to file a challenge against my patent, what reasons might the PTAB use to decide not to start the trial, especially if the person challenging me is a big company and I'm just an independent inventor?
That's a good question. We went over some of the exemplary fact patterns that support discretionary denial. I would certainly review those, make sure, as we've sort of highlighted through our talk today to fully develop all of the arguments. So if there is a situation where you feel like there have been unfair dealings between the parties, if you have any, if there are settled expectations for patent owner and their patent, I would, any of these rationales that if you review and all the cases that the director has issued, you can sort of glean from them what the director is looking for. And then, like Judge Ankerbrand and I have said throughout this presentation, make sure you develop the arguments. You develop it all the way through so that there is a clear understanding of what your discretionary consideration arguments are.
Okay. Judge Ankerbrand, I'll ask you this question. What is the status of the latest SOP version on precedential and informative decision determinations? Is this going to be a part of the new FAQs?
It is not going to be part of the new website. In SOP2, which talks about or speaks to the designation and de-designation of decisions, the current version is revision 11 that was issued, I think in July of 2023 or 2024. We are posting an addendum to that. The addendum makes a small change, and that change is similar to the information on the director review process page. All the addendum changes is that it says that the advisory committee that the director consults will no longer be made up of 11 people, but will be made up of 5 people, one from each of the designated business units that are in the SOP and that are part of the addendum. So if you, for example, went to the PTAB resources and guidance page later today, you should be able to see the addendum. It's also noted or linked on the director review process page and on the precedential and informative decisions web pages. Again, it just makes a small change to the current version of the SOP.
Thank you. Judge Deshpande, another question related to the new page limits. When there are multiple related challenges, for example, several patents asserted in a parallel litigation, what is the director's preference on how to handle this? Should the patent owner file a single brief, which seems difficult to do under the 20-page limit, or should they file separate briefs?
So I'm assuming the question means that there are several IPRs filed. And if that's the case, you're welcome to file separate briefs for each of the cases that are involved. They may involve different considerations. There may be some IPRs might have a 325D consideration, whereas the others might not. So those are things that people should be cognizant of, is the distinctions between any of the patents that are just because they're in the same family or the same parallel litigation. There may be reasons to file different briefing for each of the cases, but I leave the sort of strategy part of it to practitioners, but those are, you're welcome to file different briefs for different patents or different IPRs that include a patent that's involved in a parallel litigation. That was a mouthful.
Thank you. Judge Ankerbrand, here's a question for you. Why not arrange the discretionary denial briefing schedule such that the decision to deny or refer the petition can be issued before the patent owner's preliminary response is due?
We don't do that because, again, we have timelines in these cases. If the decision is going to the board for referral, then let's say we stayed the patent owner preliminary response and the petition had been filed 3 months earlier or 2.5 months earlier or whatever it is. We stay the patent owner preliminary response. Then if the decision is referral, we have to restart the clock on the patent owner preliminary response, and the board has to then address everything. Also, I would note that the patent owner preliminary response does address the merits, and one of the considerations under the discretionary process is the strength of the merits when discussing parallel litigation. So the POPR is a chance to put forth the full merits briefing, and the discretionary brief is the opportunity to say, you know, the merits are weak. here's some things that are forthcoming in my POPR. By the time the director considers everything, the POPR will be filed and the director does review the POPR. So it's part of the process in some of the cases. So postponing it until after a decision on discretion doesn't make sense.
Okay, I'll follow up with another question about deadlines. If patent owner's discretionary denial request deadline falls on a weekend and is extended to a Monday, when is petitioner's opposition brief due? Is it from a month from the original due date or from the Monday when patent owner filed their brief?
You want me to take that one, or do you want Judge Deshpande to take that one? I think the rules were set up so that the briefs are due at the same time. So if patent owner's preliminary response is going to be filed on a Monday because the due date is Sunday, file your brief on that Monday. I think in practice we are giving a day or two before we I guess we wouldn't be referring a case to the board, so scratch that. I'm thinking of the patent owner's brief, but in practice, we're looking for a few days wiggle room anyway, just because we know some of those due dates fall on weekends. So again, the process was set up so that the briefs would be due on the same time. So if the POPR gets delayed by a day or two, then feel free to file your brief the same day that POPR is due.
Okay. Judge Deshpande, with the new briefing procedures, should petitioners proactively include discretionary denial arguments in the petition itself, or would the board prefer to see these arguments in the opposition brief?
I would recommend they put them in the petitioner's discretionary denial opposition brief. I think those are where we're expecting to see discretionary denial arguments. So they don't have to use any of the pages in the petition to assert those. We prefer to see them in the discretionary brief. They should at least make them in the discretionary brief. If they want to duplicate it for the petition, I'll leave that to the practitioners to decide if they want to duplicate the information, but it should at least be in the petitioner's discretionary brief.
Okay. Here's a question about when the new page limits go into effect. Are these for briefs that are due on September 1st, or are they also for briefs that are filed before September 1st, regardless of when they're due?
This is for briefs that have a due date on or after September 1st. So if they file early, they should still follow the page limit for when their brief is due.
Okay. Judge Enkenbrand, I have another question about 325D arguments. Section 325D arguments have not been a significant factor in the decisions under the bifurcated process. Has there been any discussion about moving its consideration to the full merits panel?
Again, I would commend everybody or encourage everybody to read all of the decisions and the papers filed in the cases. One of the fact patterns that we did highlight is apparent examiner error. And so that typically falls under 325D. So we do have a number of decisions where cases were referred to the board for the merits after a petitioner successfully argued that the office made an apparent error that was material to patentability. So I do think that we are seeing 325D play a role in the decisions. And I would keep making that argument going forward. And also because it's a discretionary consideration, it's not something that would be moved to the merits considerations part of the bifurcated process.
Okay. Judge Deshpande, if there is commercially sensitive information or maybe information that's protected by an NDA and that needs to be included in the discretionary denial brief, would it be possible to seal portions of that brief?
Yeah, I think so. I think you would follow the normal ordinary course as to how sensitive information is handled. We wouldn't necessarily treat that any differently. I don't know if Judge Ankenbrand has any more to expand on that.
Yeah, I think I would echo mostly what Judge Deshpande said. In merits proceedings, parties file briefs under seal quite often, and then file a redacted version. I think that's the one thing I would say is please just follow it up with a redacted version, and remember to do that. But if there is going to be commercially sensitive information, that's not something you need to make public. So file your papers under seal, follow up with your redacted information, and that's typically what happens in the normal course of a PTAB proceeding anyway, if you're using confidential information.
Okay, thank you. Judge Deshpande, I think you answered some of this before. It relates again to the deadlines. If patent owner files their discretionary denial request brief early, is the petitioner's opposition brief due 1 month from that date, or does it align with the date for the preliminary response, patent owner's preliminary response?
It aligns with the due date that was originally set for the discretionary briefing. So from whenever the patent owner's discretionary brief is due, petitioner's opposition is due 1 month from then.
So it's totally independent of the preliminary response date.
Yeah.
I think that confusion may have occurred because we had a question about what happens if the discretionary brief and the preliminary response dates, they're supposed to coincide, but what happens when the preliminary response is pushed to a Monday, because for them to actually coincide, the due date would be a Saturday. And I think what I said in response to that question is if the POPR due date slides to that Monday, then the discretionary brief would also be due that Monday.
Thank you for that clarification. Judge Deshpande, here's a question about filing. How do I file a discretionary brief? Is there something different about filing the brief itself?
No, there's nothing. You go into PTAX the same as you would. You just make sure you select the correct paper type for paper types for patent owner discretionary brief. I think is PO discretionary brief, and I think petitioners have an opposition labeled the same way. If there's any confusion, if you check out the new discretionary webpage, it's on there somewhere. I think I'm going to look real quick. It's in section 1G. So that'll give you step-by-step instructions as to how to actually enter or how to file a discretionary brief.
Thank you. Judge Ankenbrand, I'll ask you this question. One person writes, I'm seeing petitions run into 100 pages in order to meet the 14,000 word limit to fully explain the evidence. Now, how do you expect us to meet a 20-page limit and still fully explain all of the evidence? Are we going back to claim charts?
I think that question appears to relate to what is permissible in a petition for inter-parties review, which is different than the discretionary briefing. So the petition for inter-parties review should contain the petitioner's case in chief, asserting unpatentability of the challenge claims. So that's where you would walk through the prior art and your arguments supporting unpatentability and your evidence. In the discretionary brief, if you're a patent owner filing a discretionary brief, in the first instance, you would address discretion and you might touch on the merits a little bit, but say something along the line of, we've reviewed the petition and the merits of the petition are weak for this reasons A, B, and C, see forthcoming patent owner preliminary response. Same thing for a petitioner. In the petitioner's discretionary brief, there's no need to regurgitate everything that's in the petition. Instead, you can simply refer to the petition, make a few points about the strength of the merits, if that's a relevant consideration you want the director to consider, and then you can move on. So I don't think that there needs to be claim charts in the 20-page brief or anything of the like. I think the 20-page brief is more or less your arguments about discretion that can touch on the merits, but again, notwithstanding the PTAB's role on incorporation by reference, you can incorporate arguments made in the petition or arguments that you're anticipating in a forthcoming POPR into that brief, so you don't have to remake it again.
Yeah, let me reiterate that to the extent anyone's confused about arguing the totality of the merits and discretionary brief. That's not what the discretionary brief is really intended to capture. Like Judge Ankenbrand said, you can provide a few reasons as to why the merits are strong or weak, and if you want us to guide the director to the particularities, you can point to you can point to the petition, or you can point to where it's going to be in the patent owner response. So yeah, I think that should provide that much more clarity.
Okay. Thank you, Judge Deshpande. Looks like we're out of time, so I apologize if I was unable to get to any of your questions, but thank you for sending them in. I'd like to thank everyone who joined us here today. I hope you found the information that we presented helpful. I'd like to especially thank Judges Deshpande and Ankenbrand for sharing their time and answering all the questions today. You can learn more about our upcoming USPTO Hour presentations and access slides and videos on our website. Thank you again for joining us, and have a great rest of your day.